Part 1. Hiring.
Chapter 1. Common questions about the hiring process. 1. What are the key employment laws related to hiring?
The proliferation of worker protection laws over the past 40 years has severely limited employers' discretion in their dealings with individual workers. To see how far we've come in the past half-century, all we need to do is think back to the 1930s, when company foremen chose hungry and unemployed workers off lines outside the facility gate for a day's work. One mistake and the worker was fired, only to be replaced by the next poor soul waiting in line. Flash ahead to the 1960s, 33 black sanitation workers were fired for seeking union representation, bringing Martin Luther King, Jr., to Memphis to meet his untimely death. Even today, labor laws are still changing to meet the needs of particular employee groups. Doctors and engineers contemplate union representation to improve working conditions, wages, and benefits. The Americans with Disabilities Act continues to be refined and clarified, allowing greater benefits to American workers through stricter interpretation of its standards. The blistering pace of technology unleashes new tools like cell phones and the Internet, which were supposed to make life easier for all of us. Instead, they just accelerated our expectations for work turnaround. Techno-stress led to workers' comp stress claims and unparalleled incidents of workplace violence. The breakdown of the modern nuclear family led to the passage of the Family and Medical Leave Act, FMLA, a labor standard and leave law that mandated that employers allow employees time to take care of family medical emergencies. And on top of all this, legislators increased penalties against employers by including punitive damages that could render an organization bankrupt for failing to meet any of a multitude of laws enacted to protect individuals. Although we employers may see ourselves as the victims of the law of unintended consequences and a judiciary run amok with overly aggressive plaintiff attorneys looking for unlawful motives in even our most benevolent actions, we could all agree that we wouldn't want to go back. The 20th century was one of stunning progress for American workers. The pace of change in our laws continues faster than ever. The key, however, remains in our finding a balance between companies' prerogatives and employees' rights. Tell me more. For the most part, the laws that govern our companies are fair and practical. Of course, all it takes to file a lawsuit in many venues is a typewriter and a $100 application fee. Still, we need to understand the umbrella of laws that govern the workplace, not only to avoid or minimize lawsuits but also to be perceived as fair employers who look to increase profits and productivity while respecting our workers' needs for privacy, respect, and satisfaction. The easiest way to classify the laws that follow is according to company size. The larger your company, the more the laws that govern it. You'll find more information about these particular laws throughout the text. For now, this section will serve as a primer and overview. Remember that the legislature's intent in passing these laws was to protect American workers from company abuses. However, plaintiff attorneys will use these same statutes against your company as proof that you violated the law. As a result, special consideration should be given to any employee who falls within the protections of the following laws.